Go ahead.
Thank you, Your Honor. May it please the court. I'm going to endeavor to save 5 minutes for rebuttal. The district court acknowledged that federal agencies have authority to examine their existing grants, determine whether they're statutorily entitled to impose conditions, and then impose conditions inconsistent with the president's priorities. So the only question in this case really is whether the district court properly construed the various instruments at issue in this case to do more than that. And the text of those provisions, as well critically as the implementation of those provisions in the months that preceded the district court's preliminary injunction, make clear that the district court was wrong about that.
Wrong in the sense that it seemed like the district court thought he was bound by the 2018 decision and the executive order that was issued there, but there seemed to be some differences between the executive order there and the executive orders that were at issue here.
That's correct. And I think it's correct both that the district court seemed to regard itself as bound and that there are significant differences that lead to a different result.
It certainly is bound. I mean, bound as to what is the question, but it's bound.
Right. It's bound in the sense that it's binding precedent. It's not bound in the sense that it's controlling precedent because it doesn't control this case because there are differences.
Can you tell me what the differences are that matter?
Sure. The first thing, just sort of at a general level, and I'm going to get into the specifics, is, these are two different executive orders with different text. And
let me ask a question about that. There was also a third executive order, right, after the preliminary injunction. But the district court was clear that he understood that his order applied to the third executive order as well. And as I understand it, your notice of appeal included the clarifying order, at least, which dealt with the third executive order. So is the third executive order before us as well?
What's before you is the district court's injunction.
Right, which covers the third executive order.
Well, part one of our submissions, as you know, is that it's not entirely clear what the district court's injunction covers because...
But he said that quite specifically, as I recall.
Well, but he didn't say we couldn't implement the third executive order at all. And his reasoning actually said that there were many aspects of the third executive order that he liked.
But all I'm saying is it's before us, and it ought to be part of the question of what does this set of executive orders do together?
I guess I'm not sure I agree with that. The district court's opinion was the district court issued a preliminary injunction because it found legal defects in two executive orders and one directive issued by the Attorney General. And if the district court was wrong that there were legal defects in those things, then its preliminary injunction should be vacated. Now, I agree with Your Honor that if one of the consequences of the district court's injunction is to prohibit the department from carrying out lawful directives in the third executive order, that's relevant to this court's analysis. But I do want to get back to your original question because it's obviously the central one in the case about the differences. So just starting with the text of the executive order, what this executive order says, and I'm speaking of the principal one that the parties have focused on, is that agencies, the two specific agencies, are to evaluate and undertake lawful measures. And that language, the evaluate in particular, which was absent from the previous executive order, if you just saw that in a vacuum, it's totally clear what it's telling them to do. It's telling them to look at the various grant programs that they have and decide whether...
And maybe you can give the follow-on. What has been done? I guess now nothing because it's enjoined, but before you were enjoined, there weren't any grants, or I guess there was one grant, the HUD COCs were the money there was denied. Were there any others that the department had taken? Any department had taken action to deny funds to a sanctuary city?
That segues nicely to my second point, because what had happened was the Department of Justice and the Department of Homeland Security. And this is a fundamental difference from the last case. In the last case, the preliminary injunction was issued within several days of the issuance of the executive order, so we didn't have a record of what the agencies had done with these things. Here what happened was the Department of Justice and the Attorney General and the Secretary of Homeland Security directed their subordinates.
Well, first of all, the Justice Department froze all grants.
That's not accurate, Your Honor.
It's not
In this one or in the 2018?
I mean, in the bonding order freezes all the grants first.
Your Honor, the other side's brief says that, and it leaves out.
And the order says it.
Well, it says consistent with law. It says considering statutory authority. I understand that the other side doesn't think that.
Does the record show whether there was a complete pause, or was it that certain things were paused as they were? So what does the record say on that point?
What the record says, and what the district court said, and we've quoted this a number of times in our brief, is that the plaintiffs are bringing a pre-enforcement challenge because they are not identifying particular grants of theirs that have been frozen. And this is a preliminary injunction that was issued several months after the executive order.
So is the record silent on whether there actually was a across-the-board pause, or does it say anything about what kind of pause followed from the bonding order?
The record isn't silent. The plaintiffs are suing us, and they're saying you froze all of this funding, and they have no evidence that any particular grant was frozen. Their declarations go through a series of, they say we've got this funding, we've got Medicaid, we've got Medicare, we've got grants, we've got this and that, and they say we have a credible fear going forward, and this is the basis on which the district court found standing in irreparable harm. We have a credible fear going forward that these grants will be frozen. And this is months and months after this executive order was issued.
Consistent with applicable statutes, regulations, court orders, and terms, the Department of Justice shall pause the distribution of all funds until a review has been completed, terminate any agreements that are in violation of law or the source of waste, etc., where appropriate. That's what it says.
Correct. And the first clause that you read says consistent with applicable law, statutes, regulations.
Shall pause the distribution of all funds.
Right, consistent with law. I mean, the point that we're making is not that these orders don't do anything.
Well, I think that is the point you're making.
No.
It seems to me you're coming to the point of saying they don't do anything.
That couldn't be further from the truth, Your Honor. The president directs his subordinates to implement his policy priorities consistent with applicable law. And the plaintiffs want to say, when he says consistent with applicable law, he doesn't actually mean it, and he means do it without regard to applicable law. And that's what the district court said. And that's what this court said, that the executive order
and what
from
did,
28...
what did the earlier case say about the language in that executive order that similar said, to the extent consistent with law, and their discretion, and to the extent consistent with law? And the opinion said what about that?
It identified some features of that executive order that made it think that in the circumstances of that case, that language wasn't controlling. For example, it said that there was an exception. It said the Attorney General is supposed to do that except for when required, for law enforcement purposes. And it said there wouldn't be an exception if, unless it was otherwise meant to be categorical. Now, this executive order, of course, does not have such an exception. Candidly, we didn't think that was compelling at the time. That's why we were the appellant in that case. But as the case comes to this court,
it's different. You're saying,
and the panel.
But have you other than the Department of HUD continuum, the COC grants, and we can talk about that separately. Are there other areas where the NOM directive has been interpreted such that federal funding has not been provided to sanctuary jurisdictions?
I just want to be clear. You just said NOM, which is Homeland Security.
Yeah, I apologize.
But I'm happy to. That's actually a good one to talk about, because I think we were talking about how to interpret the executive order rather than the underlying directive. So FEMA is a good example. So if I could go to that.
Okay.
Now FEMA, when it got the executive order, FEMA undertook an analysis and said, okay, we're going to figure out which of our grants should be subject to immigration conditions and which should not. And that's in the record, in the excerpts of record, and discussed in the opinion and in the briefs. And they identified a series of grants, disaster-related grants, certain emergency services that would categorically not be subject to the conditions. Now, I don't know how the plaintiffs would reconcile that what actually happened with their view that this was supposed to be categorical, because it clearly wasn't. And then they identified some 12, I believe, that were going to be subject to to these conditions, and they said, no, those were the
Well, there
ones.
have been some that have been identified.
Correct.
So did the money end up going out, or it just the time period hasn't come up, or the money was going to be stopped and now has gone out in light of the injunction?
I mean, the main thing that the main thing that the agencies were contemplating doing were attaching conditions as opposed to just stopping the money. So some agencies have announced in some circumstances that they want to impose conditions and say you can't have this funding unless you agree to these conditions. There have been a number of lawsuits around the country by these plaintiffs and others challenging those on a case-by-case basis, and so a lot of them haven't, in fact, been implemented for that reason. The possibility of filing those lawsuits actually supports our position here, which is that if you think that there's an individual grant, if you think FEMA got it wrong, and that when FEMA said we're statutorily and regulatorily entitled to impose the conditions on this grant or the other grant, then, and you think FEMA's wrong about that, then you can bring a suit and you can challenge that. And they have done that. And
so
maybe they win, maybe
let me
they
ask you
lose.
that. Given the fact that what you just said, that some of these decisions have been made to cut funding, and they have been challenged, this gets back to standing. We haven't talked about that. Usually we talk about that first. But I don't find your standing argument to be particularly compelling here. If all of these jurisdictions are sanctuary cities, and it seems like you're not really disputing that they all would be sanctuary jurisdictions.
Yeah, well, I mean, our arguments are mostly merits arguments here, not
Okay,
standing
so you're
arguments,
not,
Your Honor.
you don't think there's a problem with standing?
No.
Okay.
I mean,
okay.
there may be a problem with irreparable harm because there's some,
No, that's fine. I just wanted to make sure.
Ripeness
certainly
arguments,
ripeness.
especially ripeness. So you think ripeness is a problem?
Yes, I mean, I guess it's a little hard to disentangle. I mean, basically this court has to decide whether the district court is correct that this executive order means cut off all of the funding, even though, in our view, that's...
So if the district court was correct in its reading, there wasn't a ripeness problem.
If the court,
It's a merits problem. But it would be right.
I mean, look, if the court was right, and this was an executive order that said you have to cut off everybody's funding, for everything for all time unless they stop being a sanctuary city, we lose basically all of our arguments except for the ones about the scope of the injunction, which we can talk about.
Well, what about, so meaning that you don't think there are any merits arguments?
We're not here telling you that we have authority to cut off everybody's funding in every federal program without regard to the circumstances.
You're just saying you have authority to take a case-by-case look.
Are you here to tell us that you understand that you don't have that authority?
What?
I couldn't quite tell whether you were, I mean, there are a series of merits arguments having to do with separation of powers and the 10th Amendment the spending clause. You devoted relatively little time to them, and you seem essentially to agree that there, in fact, would be problems of those sorts if there was a broad prohibition on funding for sanctuary cities beyond something that you could find authorized in a particular statute. Is that your substantive position?
I mean, when you say authorized in a particular statute, I mean, it's sort of tautological to say that unless we have statutory authority to impose the conditions, we concede that we don't have statutory authority to impose the conditions.
Well, it may be tautological, except it doesn't necessarily seem to be the position of the current administration.
No, it certainly is, Your Honor, and I would add to that agencies have identified circumstances in which the conditions should not be imposed, and so we're not claiming authority in every circumstance.
But for example, there have been this lawsuit, the one that it's been decided, I think, is the Illinois case, but there have been a series of lawsuits about 1373 and about whether there is, whether cooperation is mandated as opposed to voluntary. And that's really what's at the core of the merits of this case. And I can't tell... Should we as a court address those questions first in order to figure out what it is that lawful means so that we can then deal with what the orders mean? Are we going about this in the wrong direction? Or is your argument in the wrong direction, i.e., we don't have to know anything about what lawful would mean, but we can just say, as long as you say if it's lawful, that's enough. We can read the orders without knowing what we mean by lawful or consistent with law or anything like that.
The first thing the court needs to do is, this is the one area in which we agree with the district court, the first thing the court needs to do is figure out what these executive orders mean.
But if you don't know what lawful means in the mind of the government, then we can't know what it means.
Well, that's not quite right, Your Honor, because if the executive order could tell, the executive order on its face doesn't say, here are the circumstances in which it would be lawful to impose conditions, and here are the circumstances in which it would be unlawful to impose conditions. And you could read the executive order all day, and you're not going to answer that question. What the executive order says is, I am hereby directing you, subordinate officials, cabinet officers, to employ lawful means to carry out the president's priorities. Now, if you think that then the cabinet officers who were tasked with doing that, or their subordinates who they further delegated it down to, got that wrong, you could bring a lawsuit about that, and people have run lots of them, and some of them are before this court, and some of them are before other courts, but that doesn't mean you win this case.
Do they have to wait till the money is actually denied, or the conditions are actually put into their next contract? I mean, that's what their concern is. How do we run a municipality or a county if we have no idea what the governing rules are?
Well, I mean, when the government, in an individual case, when the government says, here we are, sending out a notice of a funding opportunity, or we're imposing a grant, or we're negotiating a grant agreement, and we want to place these conditions, and then the plaintiffs, the counterparties to those agreements can go to court, and they have not been shy about doing this. I'm not saying they should be, but they can go to court and they can say, no, the conditions you're trying to impose on us are unlawful, and then you have a ripe dispute and a concrete factual
And meanwhile,
statement.
how do they run their city?
I mean,
when this is a huge percentage of some of the city's budgets.
Well, I mean, I have two responses to that. The first is the things that they say are a huge percentage of their budgets is federal funding writ large, and there are lots of federal funds that aren't plausibly going to be subject to these conditions. Medicaid, Medicare, I mean, and not Medicare because that's federal, but Medicaid. And then the other thing I would say is, I mean, if their argument is we do not know ahead of time which conditions the federal government is going to try to impose, on federal funding going forward.
And then you have members of the administration, including the president, going around saying we're not going to give any money at all to sanctuary cities. That's what he's saying.
I mean, I'm happy to go point by point through the statements that were made, none of which really
This is a recurring problem in this court, which is what is before us? Is it the actual agency action, or is it what the president's saying? And we have, many judges who get very worried about what the president says as opposed to what the actual agency action actually says. But you would agree that we're reviewing the agency action here.
That's correct. And I mean, this case is actually easier than some in that respect, because if you go through the quotations that the other side has about things that the president and others have said, they've either expressed general desires to reduce federal funding for sanctuary cities, and we don't dispute that is a policy objective of the administration. And then the one most specific one they had, the president says, I'm preparing papers to get rid of federal funding for sanctuary cities. And if the president, and issued after the executive order,
if he does that, then we can review it.
But that was quite probably the April 28th order, which is why I asked the question to begin with. And that one does seem to go to some degree and more directly at doing that. And we also haven't discussed 218 at all. And I don't understand your reading of that, but it does still have consistent with applicable law. So everything that you're saying seems to come down to the consistent with applicable law-like language.
Okay, there were two.
In the two orders. Three orders, actually.
There were two pieces to that, so I want to make sure I get both of them. So to start with the executive order that wasn't directly enjoined, but the district court discussed it in subsequent order. I mean, the district court actually liked that one more than it liked the other ones.
Up to a point.
And that one says identify appropriate funds to be cut off. So, I mean, whatever you read that to say, it does not cut off everything. I mean, it just doesn't say that. I don't think even the district court thought that it did. The district court, I mean, this will get to our problems with the scope of the injunction and the fact that the district court seemed to think there are some things that it's hard to tell what they are that we're not allowed to do. But like, if you can't read that one and say it says cut off everything, because it says identify which funds to cut off and which not to. So that's that. Now, in terms of the other executive order, you're right that it does say consistent with applicable law, and you would need an explanation. I mean, the district court, I'm not even sure it seems like the plaintiffs in the district court are saying that, provision 2A2 of an executive order about pro rata is in fact smuggling in a blanket ban on all federal funding for sanctuary cities. I mean, that's just like obviously not right.
Why? It says federal payments to states and localities. So the payments are to states and localities that do not by design or effect, it says facilitate the subsidization or promotion of illegal immigrants. That's the basic subject of the order as a whole, or abet so-called sanctuary policies that seek to shield illegal aliens from deportation. Now, I don't know what that second phrase has to do with providing benefits to illegal aliens.
I guess two responses, one specifically to the phrase and the other to how you read the whole thing. I mean, the heading, section 2, which is this all, which is the whole provision, preserving federal public benefits. So that's a textual clue right there. And then it says to prevent taxpayer resources from acting as a magnet and fueling illegal immigration in the United States, and to ensure to the maximum extent permitted by law that no taxpayer-funded benefits go to unqualified aliens, the head of each executive department or agency shall. So that's the preamble. So the district court, I think, just sort of scraps all of that. So then you get to the text, and then you asked about the last part. And of course, sanctuary policies could be aided by measures having to do with pro rata. For example, some sanctuary cities are quite proud of the fact that they don't want people to have to reveal their immigration status. And they say, you can get these benefits and we're not going to find out that you're not lawfully entitled to be in the United States and therefore would be subject to immigration enforcement. And if you do that, then you're going to be giving, in many circumstances, benefits to people who are not lawfully in the United States, which presents the problems that the executive order states. And I mean, this might be I'm happy to take more merits questions. This might be a good segue to the scope of the injunction, which is, obviously the court doesn't need to get there because the injunction is just erroneous and should be vacated entirely. But, if the district court thought, there are things that the district court thought that the government was perfectly entitled to do that we're still enjoined from doing. Like, the district court said, of course you can evaluate whether certain conditions are allowed or not, but the injunction says you can't do anything based on these executive orders. And if you thought that this provision, said, is a blanket ban, then you could say you can't have a blanket ban. Now, that would be erroneous, but probably not as practically consequential as the preliminary injunction we're laboring under right now. But what you can't do—
Because that would allow you to still do an individual case-by-case analysis.
Which is all we're doing.
Right.
Now, I'm not here to tell you that we acquiesce to such an injunction,
right,
because it would be legally wrong for all the reasons we've identified. And the district court has made clear, especially when it starts talking about how we have to comply, not just with the letter, but also with the spirit of its injunction, that being under an injunction in this area is problematic. And so that's why, and for all the reasons I've already said, the injunction in this case should be reversed outright. But at an absolute minimum, it needs to be narrowed and to whatever the problem is that this court identified, and also, incidentally, to the federal agencies that are actually defendants in this case.
How about we give you some time for rebuttal?
Thank you, Your Honor.
We appreciate your argument.
May it please the court, Karun Tilak for plaintiffs' appellees. We agree with counsel on the other side that the issue on appeal here is quite narrow. It's whether these executive orders do affect a categorical directive to agencies to condition funds to jurisdictions that limit assistance with civil immigration enforcement, so-called sanctuary
The district court
jurisdictions.
seemed to think that you could do a case-by-case, program-by-program analysis and decide under the law whether you could attach immigration-related conditions, correct?
That's correct.
So if you arrived as a new administration and you decided you would like to attach immigration restrictions to as many programs as you can, and you wanted to give that directive, wouldn't it look like this? I mean, that's essentially what this says, is this is what I'd like to accomplish to the maximum extent that it can be done. Now, everyone go and figure out whether you can do it. And yet it's immediately, the whole thing is enjoined, so you can't even look at anything. And the district court plops itself in the middle and everything has to run through me.
No, Your Honor. In terms of the scope of the injunction, it very clearly only targets a categorical application of all funds from an agency or from the executive writ large. But
It's any actions that implement specified paragraphs. And the broad instruction to go out and figure this out is among those.
Well, Your Honor, the specific language of, we'll start with Executive Order 14159.
But I just want to get back. I mean, your position is if we said, just to be clear, the district court's injunction does not prohibit a case-by-case analysis, you're saying that's fine because you don't think that's what the district court did.
That's correct. During the hearings and the transcripts in the court's order, it made clear the administration can continue to do case-by-case evaluations.
This sentence is enjoined from being carried out by any executive branch official. The Attorney General and the Secretary of Homeland Security shall, to the maximum extent possible under law, evaluate and undertake any lawful actions to ensure that so-called sanctuary jurisdictions which seek to interfere with the lawful exercise of federal law enforcement operations do not receive access to federal funds. That is just a direction to figure out whether you can do this, and to the extent you can, do it. And yet, that sentence is enjoined.
We disagree, Your Honor. We think that that language is a categorical directive. Counsel on the other side focused on the word evaluate.
How is this categorical? An instruction to evaluate and undertake lawful actions to the maximum extent possible under the law.
I think, Your Honor, this court's decision in the 2018 decision in City and County of San Francisco versus Trump is highly instructive.
It's highly instructive because we said that there was an absolute categorical bar on the plainest language, and I don't see it here.
Well, Your Honor, if I could point to that 2018 executive order, it in fact included quite similar evaluative language. So that 2017 executive order directed that the Attorney General and Secretary of Homeland Security shall, quote, in their discretion and consistent with law, ensure that sanctuary jurisdictions don't have eligibility for federal grants. It also said that those officials—
That seems to be totally different.
Well, Your Honor, that again vests discretion in those officials to take no action or take some action.
It sure does, but it says take action to deny. I mean, they still have discretion, but it directs them to use that discretion to just deny, without an analysis, any funding to sanctuary cities. That's not what the executive orders here do.
Go ahead.
Sorry.
Answer first.
Well, Your Honor, it says in their discretion and consistent with law shall ensure, so they have the discretion to do nothing if this was truly about acting consistent with law in the 2017 executive order. It also told those officials to maintain grants that were, quote, deemed necessary for law enforcement. Again, vesting those officials with
discretion. The wording of the current 1459 is extreme, 14159 is, well, it's at least ungrammatical, but evaluate and undertake any lawful actions. I don't understand how you, it doesn't say evaluate and if you find that it's lawful, do it. It says evaluate and undertake. And then it says to ensure that so-called sanctuary jurisdictions do not receive access to federal funds. And that's a generic statement.
That's correct, Your Honor. And the directive language in the 2017 executive order and this one is remarkably similar. That one said that those officials shall ensure that sanctuary jurisdictions, quote, are not eligible to receive federal grants.
We said that executive order unambiguously commands action and that the savings clause cannot override that instruction. I don't see a similar categorical instruction that you must take action that can't be overridden by savings language. This all seems to be conditioned and wrapped around by these kind of qualifications.
Well, Your Honor, I think the key language here is the undertake actions to deprive sanctuary jurisdictions of federal funds. Again, this is also in the context.
You don't deny that they could take those actions. I mean, your argument seems to be this money we have a constitutional right to this money, and nobody can even look at whether it's legal or not legal to give it to us. We have to have it and stop. Any evaluation. But then what you're saying now is, no, they can do an individualized analysis.
Our argument, Your Honor, is that the president does not have the power to categorically direct that all funds be conditioned or withheld from sanctuary.
That may be, but that's not, I mean.
And that's what we interpret this executive order and the
You're
executive
pushing
order.
it at an open door. They don't claim that that's what it means.
Well, Your Honor, I take counsel's representations.
What's ironic is you both seem to have the exact same position here. And here we are with an injunction that's entered. You're saying we don't want a unilateral executive order that prohibits all funding. They're saying we hear you. We've done it so that it doesn't do that. They're saying all we want to do is do an individualized inquiry. And you're saying we agree you can do an individualized inquiry. So I mean, I'm almost to the point where it's like, what's the fight about?
Well, Your Honor, notwithstanding counsel's representations, and I know, Judge Nelson, you asked about what actions agencies had actually taken prior to the executive.
There does seem to be one issue, which is that, and we didn't get into it because of time, but the continuum of care from HUD, that did seem to be, correct me if I'm wrong, money to a specific, that was specifically designated to be dispersed, and it was stopped from being dispersed. So that does seem to be exactly what we're saying should be looked at and might be a proper injunction.
Well, Your Honor, HUD is one example, and for HUD, we would point to the April 7th letter from Secretary Turner, which invokes these executive orders and says all HUD grants will now, have conditions about sanctuary jurisdictions. So here, what the real issue
basically has said the same, as I understand.
Yes, and it's not just HUD, which is the point.
Let's back up a minute. One thing I have a real problem with is this order, not the other one or the other two, is specifically directed at the Attorney General and the Secretary of Homeland Security. I understand that the 2017 one was also, but how do you get to the government as a whole from that? Is it because the Attorney General is enforcing everything? I don't understand it.
Well, you're correct, Your Honor. Executive Order 14159 is directed only to the AG and other secretary. The other ones are more broad. Notwithstanding that, we have evidence in the record that was before the district court that showed that the Department of Transportation, for instance, invoked that exequitive order.
Well, I thought the Department of Transportation actually didn't invoke it. It used the language, but it didn't invoke it.
Well, Your Honor, we in our request for judicial notice, we provided the press release that accompanied the April 24th letter.
I see, but it's not in the letter. Okay.
And that press release was linked in briefing before the district court. We just provided it as the press release itself. That very specifically does invoke the executive order.
Then they can't read, but then we're back to the same question. I mean, we can invoke it because it's, we could tell them that it's not in fact authorized, but still, what is the theory about why an order that applies to the Attorney General and the Secretary of Homeland Security applies to everybody?
Well, the language of the executive order talks about federal funding generally. Again, the president's statements and other officials.
Well, 14218 applies to every executive department.
Yes, correct. 14218
applies
does.
to everything.
Yes. So even if 14159
and 287 applies to everything.
Correct, Your Honor. And with respect to 14287, I know, Judge Berzon, you had a question about that. What the district court's May 9th order said was Executive Order 14287 only calls for identification. That's permissible to do a case-by-case of individual evaluation. What's problematic is when the White House issues a fact sheet accompanying that executive order that says, actually, the purpose of this executive order is to withhold all funding.
And it says, shall identify appropriate federal funds to sanctuary jurisdictions, including grants and contracts, for suspension or termination as appropriate. Presumably that means do it, not just make a list.
Correct. So the district court, again, drew this distinction where the administration can do the individualized identification. It used the example of DOJ burn JAG grants or COPS grants that were separately challenged last
I
time.
just don't see, you seem to read the injunction as allowing an individualized inquiry, and I don't think that's true. I mean, but then you would not object if we issued an order, ordering the district court to modify the injunction to specifically allow an individualized inquiry into the grants.
That's correct, Your Honor. The district
court said that several times. It just didn't put it in the injunction. And
it's not. It may not be in the injunction language itself. It is written in both the district court's May 3rd order and the May 9th order, where the court talks about the constitutional principles at play and says very clearly, what I'm not doing here is preventing the administration from engaging in an individual case-by-case analysis, and if there are specific grants.
I don't know. I guess I'm just coming back to this conclusion that maybe we need to work on the mechanism to do this, but there doesn't really seem to be a dispute in this case at the end of the day.
Well, Your Honor, I think, again, at the time the court issued its injunction, what it had before it was this text of the executive order, which is the executive orders, which are quite expansive, and agencies that at the time were taking action to include conditions requiring cooperation with immigration enforcement in their general standard terms and condition, which are intended to apply across the board to all of those grants. In that context, the district court did not abuse its discretion in looking at those actions and concluding that the agencies were interpreting these executive orders quite broadly.
So, is it the agencies seem to have written their proposed conditions fairly broadly and with a little bit of caveats. But the government's position here on the merits seems to be that the authority is actually to do this relatively narrow. I mean, at one point you said, or the district court says, they agree that they can't, they have to have a close nexus, and they agree that they can't not spend money that's been appropriated, and they agree and all that. Have they agreed to all that, in fact?
Yes, Your Honor. Actually, in the transcript of the hearing on the PI motion, which is at pages 175 and 176 of the supplemental excerpts of record, there was an extended colloquy between the district court and the lawyer for the government where they expressly conceded these broader
constitutional. It doesn't look like the agencies
conditions.
agree with that, because the way they're writing their conditions seems much broader than that.
And that ultimately gets to the issue of why we need a court order that enjoins the categorical directives that we believe are in these executive orders, and then at the time of the injunction, the agencies appear to also be implementing. Of course, if circumstances have changed.
Can't you challenge that? So an agency comes in and says, we're going to add this restriction to all of our grants from here on out. That seems like a final agency action that you could then challenge. But why do we read that in at the front end? I mean, that presupposes that they've done what the executive orders say. They've looked at all this. They have rightly or wrongly made a determination that a certain restriction is warranted. Okay, challenge it. But that's not what the executive order does.
Well, Your Honor, the challenge here is to the executive orders. The relevance of the agency actions
But that's my point.
are...
The executive order doesn't do what I just described, and what you said you really complained about is these agency decisions to impose these restrictions on funding. And that is a completely separate case. That's not what we have before us now.
Well, we respectfully disagree that the executive orders do, in fact, direct a categorical directive. And to the extent there were any ambiguity, what the agencies were doing is evidence of how those executive orders were interpreted.
I disagree with you. I don't think that is evidence of that. That what it is it's evidence to the contrary. It's evidence that they are looking at these on a case-by-case basis. Just because they come up with one general restriction that should apply across the board, that doesn't have any bearing, in my view, on what the executive order says. And to the extent it does, it suggests exactly what the government is saying the executive orders mean.
Well, when the agencies implement the executive orders by saying all of their grants are going to be conditioned on cooperating with immigration enforcement, essentially targeting sanctuary jurisdictions, that's evidence that they are applying those executive orders to all agency terms. The general terms and conditions, for example, Department of Homeland Security, say that they will apply to all federal financial assistance awards.
Is all of this sort of covering up a basic merits disagreement about the issue of the kind that's in the Illinois and New York and Colorado and so on cases about what is it that the federal immigration laws actually can require of the states?
No, Your Honor, those are not implicated here. Here, the only
Well, it seems
issue.
to me they are implicated here because that's really all this issue about. If we were in agreement about that, if the government and the plaintiffs were in agreement about that, then we therefore knew what to the maximum extent possible under the law was. And for example, the maximum extent possible under the law did not permit limiting funds to localities that wouldn't honor detainers past the period of a sentence. Then if we get down to the nitty-gritty about what exactly are we arguing about, then we might have a different problem. It seems to me that what's really happening here is that the plaintiffs and the government, even though they purport to agree on the basic legal principles, really don't.
Well, Your Honor,
Merits principles.
the merits principles on the separation of powers here, this case, is whether these executive orders categorically deprive funding. If they do, there's no disagreement between the parties.
I want to make sure I understand the scope of your constitutional claims, because part of the district court's analysis is that, the executive violated the separation of powers by attaching conditions to spending that Congress, in the exercise of its spending clause power, had not clearly established. And so it was usurping that authority and acting in the absence of it. But part of it seemed to be just a core 10th Amendment authority that seemed to suggest that even if Congress did itself attach these conditions, you were immune from them. Are you making any argument of that second kind?
To the extent that this is withholding all funding, we do have a 10th Amendment claim that would be coercive under NFIB versus
Congress could, in your view, Congress does not have the authority to say that you will certify compliance with 1343 or you're not getting anything.
For any funding, Your Honor, I think that's not this case. If it's just withholding all funding, we may have a 10th Amendment claim. But I think here the separation of powers is
does Congress need its spending clause authority in order to impose 1343 on you?
Your Honor, I think that would depend on analysis of how they do it, on the language of Dole and NFIB and the impacts. But again, that's not the case.
No, but Dole was a conditioning authority. They actually pointedly did not decide whether Congress had the authority to impose it directly. But maybe Congress, in the exercise of its authority, which is fairly plenary over immigration and naturalization, can in fact direct the states not to do things that interfere or impede with the execution of federal law. And if it can do that directly, then why can't it say, we're going to deny all funding to anyone who impedes federal law in our view?
I think, Your Honor, that comes up against this court's decisions in United States versus California and other cases dealing with immigration enforcement and local autonomy.
I'm talking about Congress's authority. And do you have a 10th Amendment argument that is not dependent on a spending clause argument? I understand the spending clause argument.
I think for purposes of this case, our 10th Amendment argument is conditioned on the spending clause part of it, on the coercion aspect. But I think if the court were to find that this were categorical directives, then the 2018 decision in City and County of San Francisco is binding, and the court should resolve it on separation of powers and not reach the remaining issues. Very briefly, on the second executive order, 14218, I think our first argument is that the pro rora statute arguments that appellants raised were never raised before in the district court in the PI briefing. It's not that they made arguments as to 2A2 and raised a different framing here. 2A2 doesn't appear in the PI opposition. They only mentioned 2B. Pro rora makes no appearance. So we argue that it's waived, and the district court couldn't have abused its discretion by not considering an argument that was never presented. Even if it were, their reading of the statute of 2A2 is implausible, in particular because they say it effectively is just a policy statement, an aspirational mission statement of what will be accomplished. But But if we look at 2A, it very clearly directs action. It says that all agencies shall. 2A1 directs a very specific action, identifying certain federally funded programs. And 2A3 is about enhancing verification systems. So when you have those, it would be very odd to have a general policy statement in between. And for those reasons, we believe that the district court's injunction should be affirmed and that it only applies to a categorical application of these executive orders.
Okay, thank you. Thank you for your argument. We'll give you 2 minutes for rebuttal.
Thank you, Your Honor. I just want to talk about why we're here, because I think that's the central question here. We're here because the district court's injunction doesn't just prohibit a categorical approach. The district court said what FEMA did was no good.
I tend to agree with you, but it's very odd that we have two parties that seem to be largely aligned on what could or could not happen. And it seems like the only thing is, what does the district court order do? And we just need to clarify that in some way or another.
Well, also what the executive order does, because, I mean, there shouldn't be an injunction at all in this case.
Right.
And the district court, recently said, HUD's thing was impermissible under my injunction. HUD's not even a defendant.
That your argument on HUD? I mean, because HUD, you don't disagree, is that is a individualized inquiry where funding has been stopped, correct?
Right, and people have sued HUD and said HUD doesn't have authority to do that.
You're just saying the injunction is improper here because HUD is not a defendant.
It's not just because they're not a defendant. It's also because you would have to say, does HUD or does it not have authority to impose these conditions on the grant programs that are at issue? And I think the district court sort of took that issue up in what it described as preliminary injunction compliance proceedings. But if you want to write a complaint that says, HUD has imposed this condition, we think it's unlawful for HUD to do so, and here's what the program says, and here's why immigration conditions aren't permissible, you can write such a complaint. Lots of people have written those complaints, and some of them have even gotten injunctions. But that's not this complaint.
Is that the reason for pointing to what HUD did and what DOT did is to demonstrate that the agencies are not interpreting the order as you are asking us to do.
I agree that I guess I would make 2 points on that. That is one thing that the other side is saying. Now, what HUD and DOT have done, I see I'm over, but I'm going to answer the question. What HUD and DOT have done is consistent with what the orders are saying. It's just that there's a disagreement at the back end about whether HUD was right, that it had authority to do this for all of its programs. And you could think that HUD was wrong, and you could think that DOT was wrong.
Well, but it's supposed to be consistent with law.
It is. And,
right. And it seems extremely unlikely that everything that HUD does deals with immigration enforcement. Probably none of it does, or almost none of it.
I mean that's not true, because there's grant programs that go to people and you have to verify their immigration status. Right. So it's not none of it. And I guess my point is just, if you have an issue with what HUD has done, you can sue HUD and identify the things that HUD has done that you think are wrong. HUD,
regardless, HUD's determination is based on a separate agency action. It's not. Your point is it's not appropriate to just challenge the executive order and then roll HUD into it. If you want to challenge HUD, challenge that action.
Right, which has been done. And people are challenged.
In other cases.
In other cases, right. Exactly. Not in this case. You're not going to find any of this in the complaint.
So before you sit down, can you address the continuum of care program which Judge Nelson raised with your opponent?
The HUD program.
This is still the HUD thing?
Yes.
Yeah.
The specific HUD thing.
Right. The particular suspension of a grant in that case.
I guess I'm not sure I have much to say beyond that. It's the subject of other litigation. There's some there's actually an injunction separate from this case against that, and I believe the current status of that is the government is sort of on its appeal time and deciding whether to appeal an order relating to that, and so the government could may appeal and argue in that case that HUD had authority to do.
What court is that case in?
I don't want to lead you astray. I think it might be a San Diego case, but I don't want you to hold me to that.
But it hasn't yet been appealed.
I I apologize, Your Honors. I don't want to say something that's wrong. To the best of my recollection, I know that has been challenged in other cases. To the best of my recollection, there's an injunction and an appeal hasn't yet proceeded.
Well, there's two injunctions.
Well, there's an injunction in this case, too.
I know, exactly.
But this is sort of a tack on to a case that's about something else. And I guess my point would be, and so I may have the procedural posture of the other case wrong, and if I do, I apologize. I don't want to mislead the court to say I'm certain. But the point that I'm making is a much more fundamental one, which is that if you think that HUD has misinterpreted its authority, you should sue HUD, which people have done, and then you can get an injunction or not, and we can appeal or not, and we can work it out in a concrete context. And that goes to sort of the ripeness point. And I think the problem here is that, yes, I wholeheartedly agree with the points that Judge Berzon made earlier, that there is a lot of disagreement between the parties about the specifics of the circumstances.
But they should be handled in the concrete cases in which those disagreements come up.
Absolutely. I know I'm way over time. I'm happy to answer any additional questions the court might have.
I think we have the arguments. It's been very helpful. We appreciate both counsel for your arguments today, and the case is now submitted. And that concludes our arguments for the day.